During Jeff Dahmer's second court appearance on August 6, 1991, his attorney, Gerald Boyle, recommended that key biological evidence be returned to the families of the alleged victims. This was just 15 days after Jeff Dahmer's arrest. Have a listen.
And that would be waived, obviously, if there is nothing there to test, that he wishes to have those parts released and not be retained. I would furthermore state for the record that I have this date contacted. If one reads the criminal complaint, much of the identification is done by a forensic odontologist. I am confident that that odontologist has retained sufficient information for which somebody in the future need be, or if that time ever came, can review his work product, determine whether or not he is correct in his conclusions and opinions. I have no reason at this time to proffer why Dr. Jensen has to retain anything further, and obviously, therefore, they can use their own discretion in returning whatever they wish to return to the members of the family.
For a case of this magnitude, 15 days is extremely early to be releasing key forensic evidence. In fact, it violated a Wisconsin statute regarding the disposal of evidence. The statute states that physical evidence must be preserved until every person in custody as a result of the conviction, that would be Jeff Dahmer, has reached his discharge date. There's no single federal law that governs retention of biological evidence for all crimes in states. State laws generally dictate the requirements, as shown in the Wisconsin statute. This statute has not changed since 1991. At this early stage, the trial had barely even started. Given that, they certainly wouldn't have known what Jeff Dahmer's future discharge date would be. The result of this decision by Gerald Boyle meant that there would be no key physical evidence to re-examine down the line. Are we to believe that District Attorney Michael McCann, the Assistant DA Gregory O'Meara, the judge, and others present didn't realize Gerald Boyle was violating the Wisconsin statute when he recommended disposing of the evidence before the trial even began? If they didn't have any physical evidence, this would have been a way to make sure nobody ever asked to see it.